one of the things I think that would help the students is for you to, in effect, introduce yourself and talk a little bit about the different things that you have done in your career, and then a little bit about what you do now. So just kind of give them background.
Okay. I'm probably not your typical criminal defense lawyer. I do things other than criminal defense, but I come from a whole family of preachers. My father is a retired Methodist minister, and my father-in-law is a retired Methodist minister, my sister is a Methodist minister, and here I am.
Still dealing with sinners, though.
Well, as I jokingly told my sister one day, I said, "You save their soul, I'll save their ass." But I joke, but I do. That background kind of carries forward in what I do, because a lot of what I do as a criminal defense lawyer, I believe in redemption, and that's a lot of how I approach what I do. I came here to Mercer after realizing rather quickly in Emory graduate school that I did not want to study and immerse myself in Middle Eastern history for the rest of my life, and came to law school at Mercer really looking for a career where what I worked on had more of a beginning, middle, and end, as opposed to, you know, studying the Balfour Declaration for 40 years. And that kind of led me to trial work. I clerked for a year after graduating from Mercer with a federal judge, which was an interesting experience. I didn't know it when I interviewed with him. When I interviewed with him, he was still nominated but had not yet been confirmed, and he practiced law in Cochran, Georgia, which is a very small town not far from here. When I called my parents, who were very interested in me getting a job because I turned down an offer from my second-year clerkship in Savannah, and they were really concerned that I have something that paid money when I graduated from law school, and I told my dad who it was. He said, "Really?" And he'd gone to high school with the Gerald Fitzpatrick, who I eventually clerked for. But we had a steep learning curve that first year. That was his first year as a judge. I was straight out of law school, and it was a steep learning curve as a law clerk, and probably for him too. But it was a great experience because I got to see a lot of lawyers, good and bad, and the whole range in between, and it actually was a confidence booster in a sick sort of way, because a few of the lawyers who were successful lawyers came in, and I was looking and I thought, you know, if he can do it, I know I can do it. And that may be something that can get you through your 3 years in law school. Pick out somebody in the third-year class, and if he or she can do it. I will not name who that person was for me when I was here. He's probably making a lot more money than me now, but anyway, it was a confidence booster. From there, I worked for a couple of years with a large Atlanta firm that had an office here in Macon. I then worked for about 6 years in the U.S. Attorney's Office as a federal prosecutor. I left that in '95, and I've been in private practice with a firm for a period of time. Then I had a partner, and I can't get along with anybody apparently, and so now I'm by myself. But that's a condensed version of who I am and where I've been.
Well, could you describe for the students, I mean, I've asked this question of others that have been sitting in that chair this semester, but is there a typical day for you, or can you describe a typical day for you in your kind of practice?
I don't think there is a typical day. Like I said, I do things other than criminal defense, and about half my practice is a civil practice, and so that tends to be more predictable and routine. Every day, the one thing that does not change about every day is keeping up with communications with people, and emails are a ball and chain. And I know that sounds mundane, but a typical day begins with trying to sort through emails, making sure I flag what has to be taken care of. You know, you prioritize things. This is what I need to accomplish in the next few months, this month, this week. This what has to happen before 5 today, or I've committed malpractice. You know, and so that's the only thing that's typical is that happens every day. Almost 7 days a week, but every day that happens. But after that, I mean, you never know what will happen. A call may come in unexpected that law enforcement agents are at somebody's house serving a search warrant, and they don't know what to do, or somebody's just gotten arrested and they don't know what to do. A detective has called and says he wants to talk to so-and-so about some text messages that the prospective client has had with a minor person. So you just never know what will happen.
Let's talk particularly about the criminal defense side of your practice. Can you tell us what kinds of cases that you tend to handle these days? I'm sure that's changed over time, but what kinds of cases in that part of your practice do you handle?
Really, pretty much everything. I do not, I've not done death penalty work, and I've just never ventured into that area, and that's a specialty unto itself. I can tell you, after I left the U.S. Attorney's Office and wanted to do criminal work, but of course I didn't have a client base with me, I told the magistrate judge here that I'd like to be on the appointed list to do some appointed federal work, just to keep my hand in it and before I began to get real paying clients. And he asked me, he said, well, what kind of cases do you want to do? And I was like, gosh, I didn't know I got a choice if you're doing appointed work. And so I was still kind of in the prosecution mode and viewed drug dealers as the devil incarnate. And I told him, I said, well, I guess I'd really rather not do drug cases. And he's like, okay. And a few weeks later, he calls me up. He says, Charlie, I got a case for you. And I said, okay, great. And he said, it's not a drug case. And he just starts laughing. And I said, it's a child pornography case, isn't it? And he said, yep, it is. And so that was the first case I had. And that was absolutely disgusting. It was, you know, no question that the guy possessed child pornography. He had a whole Rubbermaid container full of it. You can tell this was a long time ago because it was all on those 3.5-inch floppy disks, which he had organized neatly with the emails where people had sent him the child pornography, and he had sent child pornography to other people. So there really was not any question about whether or not he possessed child pornography, whether he'd sent it to other folks. The only issue was whether the search was good. And I filed a motion to suppress. We had a hearing on it, and I'm questioning. I know I've gone far afield from your question.
No, I want to hear this story.
We're down the rabbit hole now. But I'm questioning the agent who was a friend of mine. We had tried the first case that he ever had as an FBI agent go to trial. I was the prosecutor on it. And I'm questioning him about the search and some inconsistencies in the documents. And when you're in trial or in the courtroom, you just kind of get into the zone of focusing on what you're doing. And so at one point I'm asking him something and he's trying to answer something else, and finally I go, Agent McClendon, isn't it true that you, and I can't remember what the question was, he just looked up at me like, what are you doing? The search got suppressed, which was good for that individual. And that case taught me a lot. And I actually talked with the agent some later about it. because he was not happy that this guy walked. And just to kind of give you the perspective of how icky it was, that's a legal term. The guy was out on bond, and when he would meet with me in my office, I'd put the pictures of my kids in my desk drawer because I just didn't want him to look at them. But my conversation with the agent, Greg, was, I said, well, Greg, I said, I bet you'll never make that mistake again, will you? And he said, no. And so, a very long, rambling answer, I do. If you have success in something, you tend to get more of those types of cases. And so, I've gotten more calls after that from the then magistrate judge, where he would start laughing when I picked up and I knew what kind of case he was sending me. And then I've handled some more of those cases. I don't particularly like those cases, but I do them. And then fraud cases, drug cases, gun cases, the gamut, really.
Okay. What about molestation cases?
Yeah.
Okay, so you've defended folks accused of child molestation.
Yeah.
These kinds of cases, your clients may not be the kind of people you would have chosen to hang out with. What gives you satisfaction about this work?
The satisfaction is on multiple levels. Some on the larger scheme. Until you've done it, you don't really appreciate the satisfaction of being involved in a case, filing a motion to suppress, and prevailing on that motion to suppress. And the reason you've prevailed is because your argument has upheld what our Constitution means, and that your argument has put meaning to the Fourth Amendment. And those protections are important beyond, you know, the individual that may be sitting across the desk from me or may be sitting at council table with me. And those protections are important for all of us, and they get enforced on an individual basis. That's a tremendous amount of satisfaction. On the just more personal, selfish level, there's nothing like questioning a witness and getting good, favorable information from a witness who does not want to give it to you. I mean, that's a blast. It's just fun. If you like trial work, I mean, if you don't like trial work, it's just a reason to eat more Maalox. But if you enjoy trial work, I mean, there's nothing more fun than questioning a witness, to me, and really having to go by your instincts of what's going on and read the dynamics of both questioning the witness and the jury, if you're in front of a jury, or the judge, and getting information from that witness that they don't want to give you. So that's fun on a more personal level, and that's rewarding. And I can't remember what else your question was.
Well, that's all right. I've got more. Most of your clients are guilty? Factually guilty?
I always tell my wife that none of my clients are guilty until the jury comes back. And to me, guilty is a phrase that is associated with a conclusion that the state has prevailed in their ability to impose some type of sanction for this person's conduct. And I'm not intending that to be a cop-out, but that is what guilty is to me, because that's what's relevant when you're engaged in criminal defense. What's relevant is not did he do it or not do it? And I can't look at my clients as, well, I know I'm defending him, but he's really guilty. I can't do that because if I wind up going to trial, I can't be talking to a jury. I mean, they'll see in your eyes that you think this guy's guilty. And so I can't look at it that way. I do look at, I mean, obviously I've got to be cognizant of, you know, what facts have occurred and what facts haven't occurred. But guilty is a legal conclusion. It's not a factual conclusion.
Okay. Well, let me rephrase it then. You've had clients who did it, whatever it is.
Right.
Right? And I trust that some of them you've gotten acquitted.
Yeah.
Okay. Have they ever gone on to do it again?
I've not had somebody acquitted who's gone on to do the same thing again. I have had repeat business, and it's usually been in the context of folks that I've represented that's resulted in a plea, and those people are usually lower level drug offenders. The guy that I mentioned that I represented on the child pornography charge, I still periodically will run a search to see if I come across his name in cases nationwide, because I fully expected to, and I never have. And quite honestly, I'm surprised, because those type of people typically are repeat offenders. This may be kind of the flip side of the question that you asked me. I had a case a few years ago defending well, I can tell you exactly when it was, because it was an armed bank robbery case, and the bond hearing for him was September 11th, 2001. And I'm driving down to Albany and hear something on the radio about planes crashing in the World Trade Center. And I think the only reason that I got the guy a bond is because everybody was so disoriented in the courtroom about what was going on in New York, because literally we're at the bench in front of the judge, and I can see the marshal slipping the clerk notes, you know, first tower fell. So I have a real clear memory of when that case was, but when that case went to trial, there was a lot of evidence, circumstantial evidence against my guy. He, at one point, had been a Baptist preacher, and when he was arrested for armed bank robbery, he was a crackhead.
Another legal term of art.
Yeah, yeah. He was a crackhead, and he was stealing clothes from Kmart, Walmart, and then returning them at other Walmarts to get money to buy more crack. I mean, he was just in awful shape. By the time we went to trial, he was looking like a Baptist preacher again. And the jury hung 10-2 for acquittal. And he was not retried. And since then, he has become a substance abuse counselor, works with people to help them out of their substance abuse. And here's, I guess, how this ties into your original question. My mother-in-law was friends with his mother, and so there was kind of a family connection there. And he was one of those people that everybody just assumed he had done it. And she asked me a few years after that, the question that a lot of people will ask, well, did he really do it? And, you know, want to know, did he do it and he just, you know, skated on that, or what happened? And so I did like what every lawyer would do. I gave her a non-answer. I asked her a question instead. And I said, well, Helen, let's assume that he did do it, because that, you know, by your question, you're assuming that he did do it. I said, if he did do it, is it more just that somebody who had a promising life at one point and is now a crackhead spends 10 or 12 years in prison and comes out probably still a crackhead? Or is it more just that he is not convicted, and as a result of that he's turned his life around and he's helping other people deal with their substance abuse problems? I said, what's the more just result to you? And she's never asked me again.
Has she spoken to you since?
Yes, but she's never asked me, did he do it? And so, I don't know, maybe that responds to your question.
Well, it is. And of course, what I'm getting at most basically is this question that every lawyer gets, every lawyer who's ever defended anybody who did something wrong. And that is, how the hell can you do that? Right? How can you sleep at night? How can you represent such bad people and help them walk free? And you know, my students have heard me say this before. My touchstone is my Aunt Lucille, right? If I can't explain it to my Aunt Lucille, then I'm not, you know, I'm not doing something right. So, how do you answer that question? I'm sure you get it, right? How can you represent such crummy people?
Well, and I've actually asked that question. I asked that question when I was in law school. A first-year student, I think I was a first-year student, and asked it to the criminal procedure professor, John Carroll. He's now the dean at Cumberland Law School, and his office was upstairs on that end of the building. And I remember asking him that same thing, because he had done a lot of criminal defense before he got elevated to academia. And he said, well, two reasons. One is, and he talked about just that sometimes you have to realize you're defending the system, which is what I talked about earlier, of through representing unsavory individuals, you also are protecting rights that really are important to everybody. And to try to hold the line on what the government can and cannot do to you. And then he said something else that was very true. He said, but also, as you get closer to trial fever takes over and ego takes over, and you just want to win. There's a certain amount of truth to that. And that's not a very lofty reason, but both of those things work. As I've practiced more, I also realized that, you know, most people who have done it wind up paying some consequences for what they've done. And there's probably a good many of you, maybe most of you, who have done something that violates the law. If you have worked in business and you've reimbursed yourself for an expense that really was a personal expense, but you claim that as a business expense, that's minor, but it violates the law. If you've been paid cash for a job, but you've not claimed that as income, that violates the law. If you speed, that violates the law. If you have smoked marijuana, that violates the law. And so everybody, almost everybody, and if you dig deep enough, it really is almost everybody, has violated the law. I don't think everybody who violates the law deserves to be punished to the fullest extent of the law. And so there are frequently times, there's really no question about whether somebody has done something. The issue is, what are the consequences that are going to have to be paid for that? And in criminal defense, more times than not, that's the arena that you're dealing in. And particularly because more of my practice is a federal practice, and federal prosecutors tend to have their cases together, you're dealing more with consequences and trying to to shape or limit the consequences to somebody for their conduct.
So you don't go out every week and get somebody acquitted?
No, it's every other week.
Now, one of the things we were talking about in the hall before you came in, I wanted to make sure I asked you, because you said to me that you wish that when you had been a prosecutor, that you had already been a defense lawyer, right? That you had that perspective. I wonder if you could talk about that a little bit. You're glad you were a prosecutor before you were a defense lawyer, but you would have in some sense been a different prosecutor if you had had the defense experience first.
I think so. I enjoyed being a federal prosecutor. If you're litigating, honestly, nothing beats being an assistant U.S. attorney and the power, respect, authority that you carry in the courtroom. Nothing beats that. But prosecuting, I think just by its nature, encourages you to push people into hard decisions. And that's part of what you do as a prosecutor frequently, is you put people into very difficult decisions. And one of the things that happens with fairly regularly in federal prosecutions is a husband may get indicted, and then he'll hear, well, if you insist on going to trial, we're going to indict your wife too, and y'all are both going to trial on a conspiracy charge. I've done that, and that's just offensive to me now. Part of what
and let me just note, if there's probable cause, it's perfectly legal. There's nothing unethical about doing it, but nevertheless, it's offensive.
And it's offensive because although you won't admit it to yourself as a prosecutor, the only reason the spouse is getting indicted is to put the screws, that's another legal term, to the husband, and to put him under so much pressure he'll cave and plead. And so that's what's offensive to it, is because the usual rules of prosecutorial discretion go out the window, and even though this person might not be worthy of prosecution on their own, you'll do it just to put the other primary defendant under such pressure that they'll cave. And the other thing that I realized as I prosecuted more, it was easy to slip into seeing all defendants as bad guys and criminals and not as human beings. And a lot of them are bad guys. Most of them are criminals. As a defense lawyer, there have been very few defendants that at some point I've not been able to connect with them and have a good working relationship. I wouldn't invite them to dinner, but I've been able to connect with them, and there's maybe 2 or 3 that all but maybe 2 or 3 that I've been able to find something in there that we've had some common ground, that I appreciated a quality in them and they appreciated some quality in me, so that we could connect and have enough of a relationship that I could work with them and interact with them in a meaningful way. And so when you do that, you realize that these aren't just wasted lives that should be, thrown on the garbage heap or tossed away in jail forever, at least not in my view. And you lose that perspective when you're a prosecutor, and particularly in my case, I think when you're a prosecutor and you've never defended anybody.
It's well upwards of 90% of the criminal cases end in plea bargains.
Right.
Which means that you can't, day to day in your practice, define success as getting people off, getting them acquitted. How do you define success? When would you say you have had a successful representation of the client?
when I left the U.S. Attorney's Office and started doing criminal defense work, I actually joked with my wife that, you know, we've got to redefine success now. Because before, success was, did you get a guilty verdict in 15 minutes or did it take an hour? And there's actually kind of a standard joke that in Bibb County Superior Court, the trial level court in Bibb County in the state system, if your jury is out for over 3 hours, that's a technical verdict of acquittal.
TKO.
TKO, regardless what the verdict actually is when they come back. But as far as success now, sometimes success is minimizing a prison sentence that somebody's going to get, or positioning it such that they've got some type of opportunities. Trying it on the state side, success is being able to get a plea that may be one charge as opposed to another charge, and sometimes that is success. On each case, for me, success is knowing that I've been able to work with a client and that we've been able to communicate enough so that the decision that they've made about how they want to proceed with the case is an informed decision. They understand the consequences of the various courses of action that they're going to choose, and they're comfortable with that, and then we pour our full energies into pursuing whatever that course of action is. And I mean, that really, on a case-by-case basis, is what success is if I know that the client has made an informed decision and then we're working towards whatever that decision is. Sometimes you get the result you want, sometimes you don't. But the real success is to know that the client is engaged and has made good decisions, or as good a decisions as they're able to.
You know, I assume big parts of that process are you counseling clients about plea offers. And I also assume that sometimes you've had to recommend or encourage clients to take plea offers that at least initially seem unacceptable to them. How do you talk to somebody about agreeing to go away to prison? Isn't that a hard conversation?
It is. And how hard I talk to a client about a plea depends in part on who the client is, what they're dealing with. There are some clients I have that this is not their first rodeo, and they know all about pleas and how the system works. And so there's the discussion is a little different with them. But frequently what my discussion with a client will be about a plea is, okay, here's the plea. Let's talk about what other likely outcomes are here. And if we go to trial, what is a likely outcome? Not just are we perhaps going to have an O.J. Simpson outcome, which is just unbelievable. That can happen. But what's a likely outcome? And are you willing to dismiss this assured outcome that may be 1 year, 2 years, 3 years versus a likely outcome? I had a client many years ago in a fraud case. It was a Ponzi scheme case. He was accused of basically bilking old folks out of their life savings, he and several other people. Early on in the case, he had the opportunity he could have pled and probably would have gotten a year and a half, maybe 2 years. Didn't do it, wouldn't take it. As we proceeded to trial, he still could have pled and reduced his exposure. I forget what it was, it may have been 5 years at that point. Wouldn't do it. Went to trial. Trial lasted 2 weeks. We had one juror on the trial who was not going to convict anybody of anything. And the jury hung 11-1 for conviction. He had a plea offer at that point, would not take it, because he believed that God was going to work a miracle in the courtroom. And we'll come back to that, because that actually, you're amazed how many times you have religious discussions when you're talking to folks about whether or not they're going to go to jail. And I told him, I said, well, I said, it may, and it's going to take a miracle for you to not get convicted. He goes to trial again, and he did get convicted. After trial, he's convicted. In federal court, sentences are governed by the federal sentencing guidelines, and his sentencing guidelines were through the roof. And through the roof qualifies as up to 20 or 30 years. And the judge, in a manner that probably was not completely appropriate, had communicated to the government that if the defendants would enter a plea at this point and waive any appeal, that their sentence would be capped at 10 years. And my client would not take it because he was still convinced that a miracle was going to occur. And I try not to belittle that, because that belief with him was serious. And we went to sentencing, and he got, I think, he didn't get 20 years, he got 217 months, I think, which in the federal system, you serve what you get. And at each step of the way, I would counsel him about, okay, here's what you're looking at. Here's maybe what you're facing if you forego that. And you frequently have conversations with people about, well, I just couldn't live with myself if I pled to something when I don't really think I did it. You'll have a lot of those conversations, and frequently what I'll tell them is, that's great, the plea is for 2 years. If you're in your 4th year of a prison term, looking back at those 2 years, do you think you're still going to feel the same way? If you are, wonderful, we'll go to trial. Other folks, I really encourage them, you are making a big mistake. And that really depends on if I think people are not thinking decisions through. If I think that they are not thinking decisions through, then I'll push harder to make them think. I don't know, maybe that answers your question.
It definitely does.
Here's a freebie, no extra charge for this. When you do have the client who is explaining to you how they just don't believe that God is going to let them get convicted, and I promise you, if you do criminal defense, this will happen on a fairly regular basis. Here's the response. It comes from my good Methodist background. If they tell you that, say, you remember the story of Jesus on the cross with a robber next to him? Most of the people that bring up God in this context do remember that or know about that story. I said, you remember Jesus turned to the thief and said, this day you will be with me in paradise. Yeah. I said, first the guy still died on the cross. So, you know, I wouldn't count on God springing you out of this situation.
Please stop by. Well, in that spirit, Charlie, one of the things I try to remember to do, and I actually forgot to do it Monday, but one of the things I always try to do before I turn this over to the students for their questions is to invite you, if there is anything you want them to hear besides that one, right? In addition to that one, maybe something that you wish somebody, experienced lawyer, had told you when you were sitting in those chairs as a first-year law student. Any words of advice, encouragement, anything in particular?
He actually told me he was going to ask me this question, so you would think that I would have something to say since I got a heads up. And I've been thinking about that. You know, weighty words of wisdom probably may not be my strong suit. I do remember when I was a law student and I spoke to a lawyer in Albany where I grew up, and he gave me the talk about the law is a jealous mistress. And I didn't really know what he meant, but I was just like, okay. It was just painted a bleak picture of practicing law. And there are some bleak moments, I won't kid you about that. But I guess the only words of wisdom are, you know, there's a lot of ways to practice law. And there are ways to practice law so that you're aggressive and everybody just hates to see you and hates to deal with you. But there are also ways to practice law so that you can fight hard in the courtroom and walk out of the courtroom and you and the other side respect each other for what you were doing and how you did it. And that makes practicing law enjoyable. It's rewarding. Two things that I feel like are some of the biggest compliments I've gotten. I enjoy doing appointed criminal work, and I enjoy it because the people that get appointed lawyers are usually the people that need the most help and the people that frequently, for most of their lives, have not gotten help. And so that's rewarding to me. I enjoy it. And I had a comment a prosecutor made to me one time dealing with an appointed client who I was like his third lawyer or something. He'd been through a few, just couldn't get along with everybody, and I was getting along with him okay. And he said, "How is it that you always manage to get along with your clients?" And I don't always, but I usually do. And I said, well, I don't know. It may be that I treat them like a human being when I talk to them. But that was rewarding to me that somebody had noticed that. And so I guess that's one of my words of wisdom to you. The other is a prosecutor that I've had several cases with here, a federal prosecutor. And we had finished up a case where I was, I can't even remember what it was, but she made the comment to me when we were leaving. She was just kind of shaking her head. She said, "You know, Charlie, I appreciate how hard you will fight for your clients, even when they aren't willing to fight for themselves," which is frequently the case when you're dealing with kind of the bottom rung of the criminal arena. And so I guess that's the other word of wisdom, is to do what you do with some zeal and enjoy it, and fight the good fight so that you'll be respected when it's over, and you can value what you've done regardless what your client thinks.
Well, let me turn to the students then. What questions do you have for Mr. Cox on this rainy morning. Yes, sir.
One thing you said that really stuck with me is when you look at the grand scheme of what you're doing, you're defending the rights that are important to everyone and what the government can and cannot do. But when you look at it more specifically, each case that you have, what specific emotions went through you when you successfully defended your first child porn case?
Okay. And just for purposes of the recording, I'm going to repeat the question.
You want to make sure you get it on tape about me getting some child pornography.
You've already done that. You're actually being live webcast, right?
Wonderful.
Just kidding.
If you're out there, let me say no.
You talked about your work promoting the Constitution, the Fourth Amendment, but the question is, what emotions did you have in that individual case when you knew that you had successfully suppressed evidence of somebody had possessed child pornography?
My emotions then might be a little different than they would now, because when I did that case, it was not too long removed from having been a federal prosecutor, where I would have been trying to put that guy in jail. And so the emotions were mixed at that point. I was glad I won, because as John Carroll said, at some point ego takes over and you just want to win. And so I did want to win. I was glad that I had prevailed on that legal theory. I mean, really the emotions that centered around that I prevailed on establishing that what law enforcement had done was not lawful, and they cannot proceed about going about their business in that way. And I still, realized, okay, here's this guy that had a box of child pornography and he's going back out there, and I wondered, well, I wonder if he's going to do that again. I don't know. But like I mentioned to the agent, I bet he's not going to make that same mistake again if he has a chance to try to search a vehicle the next time. I don't know. Hopefully that answers it.
Okay. I think it does. Yes, sir.
Why did you decide to leave the U.S. Attorney's Office to do criminal defense work?
Why did you leave the U.S. Attorney's Office, given all of its power and so on, to do defense work?
The simple answer is, and it's the truth, I'm just not cut out to be a government employee. I mean, that's it. It's not that the pay was bad. I mean, assistant U.S. attorneys get pretty well paid. But I'm just not cut out to be a government employee. And I was beginning to chafe at that kind of bureaucracy that you work in. And I actually had an aha moment when I was in Judge Owen's office. He's a now deceased federal judge who was at one time kind of legendary about how he ran his courtroom. But I was in his office to get a warrant signed. And I was talking to his secretary, and she'd said something about the office, and I must have groused about something. And she just made the comment, she said, well, Charlie, nobody's making you work there. And I was like, gosh, she's right. I could do something else. And so that day I started calling folks and was gone within a month or two. But I mean, that's the truth. I wasn't cut out to work in that.
You sent her a thank you note.
I've told her several times, thank you.
What other questions do we have this morning?
Yes, sir.
You said that you would like to have done defense work before you did prosecution. But how much has prosecution helped you since you've done defense work?
How much has the prosecution work helped you now that you're on the defense side?
It has helped a lot, because I think the one thing that defense lawyers sometimes miss or don't fully appreciate because all they've ever done is defense work, is how much the prosecution can just flat wear you down. And that as a defense lawyer, sometimes you may come up with all these novel theories and you miss the perspective of what the prosecution is going to focus on as far as the nuts and bolts of putting their case together. And you forget that it's the nuts and bolts that sometimes send people to jail or causes them to not go to jail. In the case I mentioned before, the Ponzi scheme case, it was a complicated case with lots of supposed contractual arrangements with people and insurance, and I mean it was really complicated, and it was supposed to be an international business of what they were doing. And the first time we tried that, when we convinced one juror that the defendants weren't guilty, we focused on all these convoluted business arrangements and everything and all these transactions. And the second time we tried it, I knew, I didn't feel good anyway, but I knew we were toast the first day when the prosecutor showed a picture to the jury of the house where this international business operated. It was a little wood frame house in Tifton, Georgia. And as soon as he showed that, the prosecution side of me said, "We're done. We are done." Because that was the most effective thing he did in the trial, was because nobody in their right mind would think an international business was running out of that little wood frame house. So hopefully that answers.
We've got time for one more. You've asked one. I'll come back to you if there's nobody else. And they're all afraid to raise their hands. So
We talk a lot about civility in here, and what I want to know is, with the type of work you do representing unpopular clients, have you ever had an issue of civility with the prosecution where they maybe thought you were a lesser form of attorney than they were?
have you had issues of civility with prosecutors?
Yes, and you know, that happens, and I usually try not to respond to that. You get that more in the state system than you do in the federal system. I don't know why that is, but that is the case, and personal attacks seem to be more common in the state system. And usually what I do is, if we're in front of a judge, I don't care, because the judge is going to be listening to what the arguments are and what the facts are, and what the law is. And if we're in front of a jury, then I know I'm going to have the chance to address the jury, and you can always turn that against somebody if they're making snide remarks or trying to belittle you, and you can just talk directly to the jury and say, I know Mr. Jones over here wants to make all these side remarks, and he's probably doing that because he doesn't want you to focus on this fact right here, because he'd rather, you know, talk about this and try to make you think something bad about me. But I'm not on trial. My client is on trial, and Mr. Jones has the burden of proving this, and he doesn't want to talk about this gap in his case. And you know, do something like that. And so then the jury's saying, well, why has he been acting like such a jackass the whole time? Maybe he doesn't have a case.
All right, Charlie, we're out of time. I wish we had more time, but thank you for being with us.